very much for coming today. I'm going to be talking about ante-nuptial contracts and why it is that they are going to become preeminent in our cases. Essentially, it divides into three different headings. First of them is the simple evolution of the common law is very much in favour of there being a system which is going to embrace ante-nuptial contracts. Secondly, the human rights position demands it. And third, it is simply illogical not to have a regime where ante-nuptial contracts are given the same force as, say, Edgar agreements. But to understand how this all came about, we have to take ourselves back to the heady days of the English Civil War in 1646. Particularly interesting area. In that time, there was, of course, a great dispute between the state and, as the individuals who were involved in it saw it, the individuals or the citizens of the country. One of the principal instruments of the state was, of course, the church. The church and the state worked hand in hand. Family courts were dominated by the ecclesiastical courts. That is, until 1646. In 1646, Parliament, by this time having some doubts about its king, decides that it's going to get rid of the corrupt ecclesiastical courts. All the clerics who used to work there would have to go off and become estate agents and so on. And this all came about, really, because of the enormous pamphleteering which had taken place following the abolition of the Star Chamber, the ability of people to promote various views. And so we have first of all, we have John Seddon, who is arguing in the early 1640s, the marriage is nothing but a civil contract. Gone are the idea of a sacrament, gone is the idea of God controlling it, or God expressing himself through the crown, or the church in order to control it. He says, no, it's just a civil contract. The two of you, you're individuals, you've got your own relationship with God, go out and agree what you can. We've got John Milton writing essays, The Doctrine and Discipline of Divorce, published in a very interesting titled book. I think we've got some of that on our walls at home, actually. The Areopagitica, in which he advances the idea also that marriage is a contract between two individuals and their God and nobody else. And so this gives rise to the idea that you can agree what you're actually going to have. It should be recalled, of course, that John Milton had legal training, and John Seddon was a barrister. These were the days of enormous altruism by members of the legal profession. It was, of course, John Cook, referred to recently, the barrister who prosecuted Charles I, who was the first advocate for a national health service. One can perhaps contrast this with the position which is described in the recent story of the barrister who was troubled on a Sunday afternoon by his local vicar. The local vicar said, we've been doing a bit of research on the internet and we've discovered that you, Queen's Counsel, member of a very esteemed set of chambers, are earning many hundreds of £1,000s a year. And we rather thought you might like to contribute to our local charities which look after the poor, and we've got some good works involving the church and so on. And you know, you've got all this money spare. And the barrister says, when you were doing your research on the internet, did you happen to notice that I have a mother who requires medical care that costs more than 3 times her income? And the vicar said, no, I didn't. And did you also know that I have a brother who was disabled in the Iraq War and is now, sadly, in a wheelchair and requires peripatetic care costing £100,000 a year? No, I had no idea, says the vicar. And did you also know I have a sister, who is not at all well, and again, she requires the need of servants to attend to her and generally deal with her because of her own disabilities. And if I'm not going to give them a penny, I don't see why I'm going to give you one. But these were different days. These were the revolutionary days. These were the days when in 1650 actual maxims were codified. These were the days when the law quite literally imposed itself above the head of the monarch. These were the days when the models of government, which were being promulgated at that time, really formed the basis of almost every Western constitution there is. There are the two trends. There's the constitutional monarchy proposals of the late 1640s, which after 1688, of course, come into force. And then, of course, there's the Statute of Government of 1653, which is the basis of the American system. There was an elected Lord Protector, elected for a term of 7 years, and there was a Senate and a House of Commons. All of this taking place, not to mention the things that were going on in the rest of civil society, the introduction of chocolate into society, opera, try and take it a bit more highbrow, the formative years of Christopher Wren, of Isaac Newton. Isaac Newton, of course, caught up in this maelstrom, these exciting times. He is estimated to have written something like 150,000 words on the subject of physics during his lifetime, and over 1 million on religion and politics. You can imagine what a terrible guest he'd be at a dinner party. Religion, politics, physics. Anyway, in this time, though, they brought in this idea that there were going to be these contracts. And although the ecclesiastical courts are restored on the return of Charles II, a lot of people carry on as before. One of the primary objectives of Lord Hardwicke's Act, of course, made famous by Valentine Grice, was that they should put an end to these contract marriages. So this is decades after the end of the Commonwealth. Still the common people are saying, well, you might have your divorces in the aristocracy and so on, but we're going to have contractual marriages. And even after it became subject to the death penalty after 1753, there still was an understanding amongst the vast majority of people that you could have a deal with your wife and you could arrange your own terms. The most famous example of that is the bride sales. If there are any family lawyers here who don't know how to sell a bride, shame on you, but let me just tell you how it was done. You would take your bride down to the local market, normally with her head in a halter, and you would offer her for sale. And normally someone you'd agreed, normally what would be termed a co-respondent now, would come along, and he would say, okay, here's 10 groats or whatever, and that would be the end of it. And the significance of it was, of course, it took place in a marketplace so that everyone would know that the wife could no longer pledge the husband's credit.